in order in the action of establishing negligence must show that the damage would not have occurred for the defendant, that is the doctor's negligence. Are the defendant's negligence materially contributed to or materially increased the risk of injury? Or if the claim is for negligent non-disclosure, had he or she been adequately informed, or she would not have accepted the treatment. A victim can take any of the following actions against a negligent medical professional. Compensatory action seeking monetary compensation before the civil court, high court, or the consumer dispute redressal forum under the constitutional law, law of torts, law of contract, and the Consumer Protection Act. Punitive action, filing a criminal complaint against the doctor under the Indian Penal Code, disciplinary action, moving the professional bodies like Indian Medical Council, State Medical Council, seeking disciplinary action against the healthcare provider concerned. Recommendatory action, lodging complaints before the National or State Human Rights Commission seeking compensation. So now, what is the accountability of the medical professional? It has been argued by the Medical Association in Santa's case that the medical practitioners should be kept out of the purview of the Consumer Protection Act 1986, as there is a scope for disciplinary action under the Medical Council Act for violating the Code of Medical Ethics and for the breach of duty to exercise reasonable care and skill in rendering medical service to the patient. The Supreme Court held that the medical practitioners are not immune from a claim for damages for negligence. The fact that they are governed by the Medical Council Act and are subject to the disciplinary control of the Medical Council is no solace to the person who has suffered due to their negligence, and the right of such person to seek redress is not affected. Now, what is the accountability of the hospital? Hospital's liability with respect to medical negligence can be direct liability or vicarious liability. Direct liability refers to the deficiency of the hospital itself in providing safe and suitable environment for treatment as promised. Vicarious liability means the liability of an employer for the negligent act of its employees. An employer is responsible not only for his own act of commission and omission, but also for the negligence of its employees. So long.
Pardon, sir. I had a question. Where some I had a question that there are some multi-speciality hospitals where the chairman of the multi-speciality hospitals are who are all in abroad, and if any of the medical kind of a cases, medico-legal cases happened, and if a patient died, the remoteness of the kind of a negligence is very far with respect to the employer or a kind of a chairman of the multi-speciality hospital. So what is your point of view in that?
So Satyanji, I will reply after my session, okay? So if anyone has questions, they can write in the chat box, okay?
Right, sir.
First thing. Second thing, if we can go for the question answer session only. So if participants have the question, I will reply. So I have no need for the lecture, because I think many people know about that, okay? So I think first I need to finish some my topic like medical negligence prevention. So first, that is the first part about the medical negligence, accountability and preventive measures. Then what is the legal challenges? Okay.
Right, sir. Right, sir. Thank you.
Okay. So anyone, if you have any doubt, please write in the chat box. I will reply in the last. Okay. So there is a serious liability, means the liability of an employer for the negligent act of its employees. An employer is responsible not only for his own act of commission, means that responsibility of employer for also he is responsible, that organization is responsible for due to employee, because that is also a responsibility of yours why you are selecting such type of practitioner. Like some doctors ask about the competency. So government organization recruiting on the basis of theoretical knowledge, practical knowledge in interview, asking question only, not perform any surgery or any treatment. Okay. Same, that is the government selection process is very tough, but in the private, what happens? Not such type of recruitment policy. On the basis of the knowledge, on the basis of the practice, on the basis of the year of experiences, they are selecting. Okay. I will show some cases of some renowned hospitals also about the medical negligence. But first, I want to give the concept and understand the concept. Okay. So now, common errors by medical professionals. Patients feel because of a feeling that they were not heard, that their needs were not attended to, and nobody seemed to care, and as a result, a bad outcome resulted due to a mistake or negligence. Some of the instances I am going to tell you. Few days back, I read one article that during the delivery there was electricity, okay, gone. Okay, so what happened? In that condition, doctors use torches for the surgery process. So first type of negligence, what you can say. And generally in the government hospitals, no proper, if there is not proper backup, or person is not going to start generator or other machine, so there is a problem. So generally what happens in the surgery ward where operations going on, so there is a proper care, proper backup is required, and many organizations, many hospitals also providing such facility. Now first common error, that is the avoidance. Compassionate gestures count. If a hospitalized patient has a bad outcome, some physician may avoid making rounds in the presence of relatives. Rounds in the presence of relatives. Okay. What happened during the COVID? Such type of negligence observed, many negligence observed. I also given a report of medical legal report on negligence. A lady died due to the negligence of the staff. Okay. So that is a very suitable thing, that there is some physician may avoid making rounds in the presence of relatives. It is important to let the patient and their caregiver to know that as a treating doctors, their problems are understood. It is a good practice to maintain eye contact while addressing the patient and put a comforting hand on the individual's arm. Comforting touch. Okay. Defensive medicine. It is better to avoid practicing defensive medicine, particularly when affordability is an issue. Victim is very likely to complain. Moreover, it amounts to medical malpractice. A medical practitioner intentionally advises unwanted investigation. So such type of things also you can observe. Okay. Failure to communicate clearly and effectively. Take time to ensure your patient understands their diagnosis, treatment, and medication plan, and then check their understanding by asking them to explain it back. This ensures instructions are probably followed and demonstrates your care towards patient. Next, failure to diagnose. Failure to diagnose is the number one reason a physician gets sued for medical malpractice. A techno-savvy patient may give, explain, ask more information. A psychologically less sophisticated patients may withhold the information and make diagnosis difficult. Nowadays, patients are relative of the patient. Okay, take two or three consultation opinion of the doctors before the surgery, then go for the surgery, and also understand about the costing of the different hospitals for that particular surgery. So such type of homework done by the patients and also relatives and family members of that person. Same in medical legal cases also. Okay. Failure to identify a complication. If a certain complication is known risk, it should be on the consent from the medical procedure. However, the consent from need not list every single complication that has ever occurred for that procedure. So that is also one reason. Inadequate follow-up. Many times, if doctor giving the prescription, checkup, but no any person going to take proper follow-up due to self-satisfaction or self-realization that he or she is now well. So such type of thing also happen. Then the patient time is spent allowing the patient to fully explain his or her concern determines the physician ability to show concern. Okay. So quality time a physician is spent with the patient, the less likely will the physician will show. What happened in the hospital, in government hospital, I have the experience. Just they ask what is the problem and give the medicine. But in the private hospital, this is my personal opinion, okay? They take proper information, patiently they listen, okay, about the problem, and also we can discuss more and more, and there is then proper medication we can receive. So what happens where government organized hospitals, where is the fee is 1 rupees, 10 rupees, okay. So they are in the hurry and there is also crowd of the patients in those hospitals. So I think due to less manpower and due to less costing, people come there and also take prescription from the doctors. But that doctors don't have proper time to listen carefully everything. And what happens sometimes there is also pressure on the medical officers to check and required number or fixed number of the patient, like minimum 100 or 200 or 300 as per the or 10 or 20 as per the specialization, as per the like such type of problems happen in the general physician cases. Okay, but the specialized cases not such type of crowd of the patient. So this is also an important thing, okay, because without listening properly, we are unable to solve the problem. Then prescribing errors, if there is any prescribing error like medication, a physician should be aware of all medication the patient is taking, including over-the-counter drugs and alternative medicine. Physicians should reinforce the importance of taking the medication only as prescribed. So prescribing errors also, that is very important. There is a proper record maintained by doctors are not, many doctors are not doing that. But some doctors are attendant of the doctor's mention name and which drugs given by the doctors are sometimes in the tertiary care hospitals, there is a scanning of the prescription. Okay, so we also need to make a proper medical data that report that data and for some years, just like in other organization and other firms. So that will be also beneficial. Okay. And also there is a review meetings or review by the senior consultant doctors that everything is going in the proper manner or not. Okay. Prevention of medical negligence. In recent times, medical science has witnessed exponential technological progress. However, healthcare delivery remains very much a human endeavor. Evidence shows that errors are often the result of not from a lack of knowledge, but from the mindless application of unexamined habits and interference of unexamined emotions. So there is a proper investigation required, no emotions, and also not in the good faith, you are not going to take the signature or anything. So your safety is also very important because your documentation is also very important if you are going for any surgery or any prolonged treatment. Okay, because if anything mislead or misbehave, so that will be beneficial for you. Also, there is a history of the patient about any allergical issues. So also you need to prevent such type of medication to the patient. Okay. Then effect protection and indemnity. So that is also very important. Okay. Burden of proof. The court has held the opinion that medical negligence has to be established and cannot be presumed. In cases of medical negligence, the patient must establish her or his claim against the doctor. The burden of proof is correspondingly greater on the person who alleges negligence against a doctor. A doctor can be held liable for negligence only if one can prove that he or he is guilty of a failure that no doctor with ordinary skills would be guilty of it if acting with reasonable care. The burden of proof of negligence, carelessness, or insufficiently generally lies with the complainant. The laws require a higher standard of evidence than otherwise to support an allegation of negligence against a doctor. One case was in a Bimlis category. It was held that the owners of providing negligence and the resultant deficiency in service was clearly on the complainant. When the damage is too remote, it is not considered as an immediate result of medical negligence. Also, next is the change in attitude. Okay, always to do the best, apologies, blaming others, clinical guidelines. So that is also need to consider by the medical practitioner. Documentation, empathy. Okay, hospital policies and also hospital policies required as per the reducing the medical negligence activities as well as claims, false claims, okay, and also need to keeping updated, okay, risk management and informed consent is required, okay, to take, okay. So now Indian Penal Code, what saying that is the law, no human being is perfect and even the most renowned specialist could make a mistake in detecting or diagnosing the true nature of a disease. It has been held in the different judgment by the National Commission and by the Honorable Supreme Court that the charge of professional negligence against a doctor stood on a different footing from a charge of negligence against a driver of a vehicle. The IPC describes, like IPC section 52, good faith. Nothing is said to be done or believed in good faith, which is done or believed without due care and attention. Good faith implies genuine belief on the part of the doctor that his or her act of omission or commission would be in the best interest of the patient. The onus lies on the defendant doctor to prove that not only the good intention but also a reasonable skill and care are exercised for the discharge of duty. IPC Section 80, accident in doing a lawful act. Nothing is an offence which is done by accident or misfortune. And without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. Accident implies without the prior knowledge or intention of causing the evil effect. IPC Section 88, acts not intended to cause death done by consent in good faith for person's benefit. Nothing which is not intended to cause death is an offence by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to any person for whose benefit it is done in good faith, and who has given a consent, whether express or implied, to suffer that harm or to take the risk of that harm. The section, okay, highlights the importance of acting on good faith and with informed consent of the person. Also, there is a IPC Section 89. It is similar to 88. Okay. View of consent in case of children below 12 years and person with a mental disorder, where a guardian is authorized to give consent. Then IPC Section 92, act done in a good faith for benefit of the persons without consent. Okay. IPC Section 93, communication made in a good faith. Criminal Procedure Code Section 124, this section does not preclude the right of aggrieved relatives of a deceased person to prosecute the doctor for criminal liabilities under IPC Section 304A. Whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description of a term which may extend to 2 years, or with fine, with both. It prevents doctor from being arrested immediately after the unfortunate death of a person. It also offers doctors an opportunity for being assessed by their peers for any of the alleged professional lapses. Today I read one article. Doctor have right if patient or relative of the patient is not in a good behavior, manner, or aggressive, so he or she can deny to take that case. So that is in the favor of the doctor. Okay, no any pressure. Now, immunity of the government doctors. The National Commission, by its judgment and order, has held that person who avail themselves of the facility of medical treatment in government hospitals are not consumers, and the said facility offered in the government hospitals cannot be regarded as service hired for consideration. It has been held that the payment of direct or indirect taxes by the public does not constitute consideration paid for hiring the services rendered in the government hospitals. It has also been held that contribution made by a government employees in the central government health scheme or such other similar schemes does not make him a consumer within the meaning of the act. Next one is the media trial. In the current situation, media is often referred as the fourth pillar of the democracy. However, it has no right to present the facts of a case in an unfair and prejudicial manner. A doctor cannot become a victim of malicious or defamatory reporting. A doctor should not be silent and should rebut the allegation. The doctor can take help of their professional association to convey the facts and support to resist a trial by media. Okay. Now, prevention of harassment of the doctors. Taking the judicial notice of incidents where the doctors are being harassed by the police in the guise of investigation and unnecessary delay in the medical evidence by way of frequent adjournments are by cross-examination. The court held that unnecessary harassment of the members of the medical professionals should be avoided. They should not be called to the police stations to unnecessarily interrogation or for the sake of the formality. The trial court should not summon medical person unless the evidence is necessary. Even if he or she is summoned, an attempt should be made to see that the people in this profession are not made to wait and waste time unnecessarily. The law courts have to respect for the people in the medical profession. The Supreme Court has warned the police officials not to arrest or harass doctor unless the facts clearly come within the parameters laid down in the Jacob Matthews case. Even a threat was given to the police officer that if they did not follow these orders, they themselves had to face legal action. The Supreme Court went on the say to prosecute a medical professional for negligence under criminal law, it must be shown that the accused did something or failed to do something which in the given facts and circumstances no medical professional in his ordinary senses and prudence would have done or failed to do. The hazard taken by the accused doctor should be of such a nature that the injury which resulted was most likely imminent. The Supreme Court has attempted to remove apprehension that prevents medical people from discharging their duty to a suffering person. Okay. Now, what is the legal implication of the medical negligence? Okay. So already I have discussed about that. Okay. Now, one video. Now, for the doctors, what the doctors can do to prevent a negligence claim from arising? That is, get informed consent. Okay. Get informed consent. That is noted. Okay. Not in a good faith oral, no. Informed consent, and that is written, that's good. Okay. Because you need to make documentation, make record. Then avoid faulty communication. No any fault, no any loose communication, loose talk. Okay, there is a proper communication required. Stay updated in standards and training. Stay. Already I told in that question. Stay updated in standards and training. So standards for the required to read that development in that field and training. Training is also required. So many of us also go for some fellowship, something. So training is also important on the daily basis, on the annual basis, on 6-month basis, and always there is a need to develop the skills. Skills development is required. Okay. Then follow up on diagnostic test and specialist referrals. Okay, that is also important. Then know the relevant policies and procedures related to prevention of the negligence. First, how to save yourself. Means no negligence or malpractice. That is as per the ethics of the medical science. If that happens mistakenly or by any reason, so what is the preventive measures? Okay. So you need to know relevant policies and procedures and also avoid avoidance behavior. So these things are very important for medical practitioners. Okay. Now there is one video. I want to share. Give me 1 minute. I think this is not audible.
It is not audible, sir. You need to share the sound as well. You need to share the sound also.
I think some technical issues.
Anyway, sir. Anyway, sir. You just proceed, sir.
So what happened in such case? Okay, there was a fracture in the right leg. Okay, but surgery done in the left leg. Okay, so this is not only negligence. This is a blunder, you can say. So there is a proper punishment required. Okay, so this is a mistake of doctor or staff or hospital. Anyone, please tell me, this is a mistake of the doctor, that surgeon or staff, that is the supportive staff, paramedical staff or hospital. Tell me. Anyone? Yes, sir. So what happened in such cases? Hmm? In such cases, what happens if that person, okay, examined by that person, examined by or by the doctors, okay, and also there is a staff, and if there is a fracture and there is a date fixed for the surgery, okay, so generally they mark the that mark on that area, that operation or surgery on that leg or that organ. So that is also mistake of the staff, and also there is need to verify by the doctor, that surgeon, that that is the that leg is that leg or not, that organ or that organ or not. So as a senior, as a person who is doing this surgery, they they also need to assure that this right or left leg, or which leg is going for the or have the problem for the surgery. There is the need of the cross verified. Okay, not have the trust on the staff only in the such type of cases, because sorry, tell by a doctor is very dangerous. Yes or no? Sorry, tell by any doctor or medical practitioner is very dangerous. So there is the proper caring or study of that case is very important. And also for this purpose, that doctors need to be mentally tension free and stress minded, not plenty of the cases or load of the surgery on that day. Okay, that is also very, so many things that which affect in the cases of the medical negligence we need to avoid, because as a simple person, as a general person at home, we are also trying to avoiding many mistakes. Okay, like we are preventing or putting the household poison at the safe area from preventing from the children. Okay, or we are using the fire for the food or for the playing, for the puja purpose, praying purpose. So that is in the prevention in a proper manner from preventing from catching the fire. Okay. So proper prevention we are taking at home and everywhere, and such type of precautions we required there. So we need to prevent from the you can say that is the such types of the negligence. Malpractice is the different thing. Negligence. So negligence always due to carelessness. Okay. So this is my view about medical negligence prevention and legal challenges. So there is the proper legal challenges. If there is the guilt, there is the things happen by the doctors, so also need to accept, and also that is very important that person not die. Okay, so because life is very important, so precautions need to take by the doctors, medical practitioners. Okay, now over to you for any question in this case.
Any questions? Any questions from the audience side? Uday Sannaki sir, you have any questions, sir? Uday Sannaki sir, Zaya madam. Thank you, madam. Thank you very much for coming to the program. Zaya madam is a very distinguished advocate and now Chief Legal Aid Counsel in the district of North Karnataka. So I really thankful for the arriving to this program, madam. Thank you very much.
I have
Dr.
one question.
Shalini madam, thank you very much, madam. You have any questions?
Sir, I have,
You have a questions, ma'am?
yes, sir.
Yes, madam.
Sir, actually, this is what is going. It's really is amazing, sir, because the first time I have, that's watched this kind of the webinar. Before that, there is such webinars are there, sir, and I have got the lot of knowledge with from the legal medical aspects. And thankful, sir, thankful lot, sir, organizing this webinars. Sir, my question is that, sir, before prosecuting to the doctors in the criminal cases, whether sanction, I know that sanction is required. So, what would you say that about the sanction?
About the
Sanctions, a sanction, permission. So, the before prosecuting the doctors, government doctors in the criminal cases, so what do you say about the sanctions? Sanction. Could you add something more than I know about that, sir?
permission to the government doctors in the criminal cases.
Yes, sir. Yes, sir, could you repeat it?
To permission
Yes.
to the government doctors in the criminal cases. Ma'am, can please repeat your question again? So, Satam ji,
हाँ sir, हाँ. Hello, sir. Her question is in to implicate the government doctors in criminal cases, the permission from the government is essential or not? That is her question.
you know when we are talking about state,
Sir, because I make something more clear about this question.
Taking the sanction, taking the permission from the concerned state government.
what happens, government doctors is sufficient to take such type of cases, but also need to report to the near police stations as well as also make the records of criminal cases. Because when we are talking about doctor to doctor relationship, doctor to patient relationship, doctor to state relationship, okay, so there we need to take the criminal cases, no issue, because life is the first thing, and also there is a need to inform to the police station, police personnel is also informed. So I think not more permission, and also as per the guidelines, they need to take the cases. Because if government doctors are not going to take the cases, the private doctors are more have the more fear. Okay. So also, if any case related to like if any road accident or any cases of domestic violence or any sexual assault cases and victim is injured, so there is a need to take the give the treatment by the doctors and also go further process for the collecting the evidence or anything.
Here, prosecuting the government doctors, implicating them in the criminal cases, particularly Section 304A, whether the sanction of the government is required.
The government sanction, actually, I am talking about in a general context, okay?
Sanction, madam, as per my knowledge, the thing that there will be a commission appointed by the government, and from that commission the police has to ascertain the factual metrics that there is a medical negligence ingredients in the facts of the complainant. In that case the police will register the case. Here the burden of proof lies upon the complainant to establish and to show a prima facie evidence that there is a medical evidence. Then if it is supported, then the police officer register the case. Government sanction only the opinion of the senior doctors is required. That's all. It is my kind of what I have learned. If it is more than that, I need to research and I will get back to you, madam. Thank you.
Yes, because I thought that just directly if going to register the any case and that should not be cause any damages to the doctors. So that's why this rule is made that the sanction is required, because who knows that the patient is
Preliminary inquiry to be made. That is for sure.
a preliminary inquiry would, in some cases it is related and in some cases it is not related, because thing is that some
the aggrieved party, the complainant party has to establish.
Yes, sir, because if the a patient is died in this situation, the preliminary inquiry is not required and it is held in by the so many judgments of the Supreme Court. But when the negligence or any offense is a minor, then a preliminary inquiry may be conducted. But thing is that so far as a government doctor is concerned, so he is a government doctor there. So maybe there is a chances that the some persons may be implicated in the fall cases. So to avoid this all the complications, the government has made the rule that in some judgments also it is said that so sanction is required that. So before prosecuting the government doctors, the sanctions should be taken.
Yes, madam. If you have any precedent, please forward in the group, madam. So we'll also get to know about it. Okay.
Yes. So I want to know something more about this. So that's why I asked the questions to the sir. So the
sir has to give. Sir will definitely answer it. So sir has any kind of precedents, he will send you, madam.
Yes, and another question is that for the sir, sir, what about could you tell me about this, sir, the euthanasia, sir? euthanasia, there is a few judgments I have gone through that the euthanasia is permitted in India. But would you say something lot about this, sir?
So, as per the available literature and right, Supreme Court, okay, so we follow that series, okay, because that is very from the country.
Okay.
And if you have further question, you can also write to me, okay. My email ID, I think Purushottamji has, okay. Because purely there are many doubts related to medical issue actually. Because these type of questions, okay, that changes.
Okay. Any doubts, madam? The thing that I will collect the sir's email ID and I will forward into the group. So where you can post questions or queries to his mail ID. Okay. So thank you very much, madam. Thank you very much. Dr. Shalimni, madam, is there? She will give a vote of thanks for all the speakers, and I request her to give her inputs of this program.
Yes, sir, I'm here. I think I'm audible, sir.
You're audible, madam.
Very good afternoon to all the doctors and the law professionals. It gives me an immense pleasure to deliver the vote of thanks for this event to all the dignitaries who are assembled here for the webinar. I would like to thank our chief speakers who honored and spent their valuable time in sharing the knowledge amongst all us regarding the medical field and the connection with the law and the medical field. I would like to thank Dr. Kalpesh Kumar L. Gupta, founder Pro Bono India legal startup, for showing a light on the liability of doctors in emergency situations during their treatment and their competency in the work. So it was a very I'll be very thankful to you, sir. And I would like to thank another our chief speaker, Professor Amarnath Mishra. He's a forensic science expert and medical legal consultant. He spoke about the medical negligence and the legal challenges in the institutions, like how to come up with that, all the IPC sections regarding that. And he also spoke about the recruitment of the doctors based on their competency in their practical knowledge. And he also spoke about the defensive medicine and the complications. Thank you so much, sir, for all the knowledge what you spoke about, what you shared with all of us. And my special thanks to Advocate G. Purushottam, sir. He is familiarly called as GP, sir, in all our Bangalore side. And for his Vidhi Pragna Karnataka Legal Services, who's constantly they are teaching, they are sharing their knowledge about the constitution and about the legal connections with the various fields. Thank you so much, sir. I would like to thank all the participants, doctors, for making this event as a grand success. Professor Amarnath, sir, also told about the media, how it is being responsible during the trouble of medical negligence. For that instant, I would like to take one instance which happened in Karnataka when the sad demise of Dr. Puneet Rajkumar, our famous cine artist, when he expired, all the people of Karnataka, they were just accused Dr. Ramanamurthy. I'm clear, sir, GP sir. So the media came in help of him, saying that it was not a medical negligence. Like that, many issues like which is more connected with the medical negligence and the media, which is coming in the middle. Media has to be more responsible while delivering these kind of news to the people. Thank you, sir, for showing a light on the responsibility of the media also. And I want to thank Vidhi Pragna Karnataka Legal Services and all the supporting partners of the program: Pro Bono India, Sejal New Foundation, Dharni Pratishtana, Rotary Club of Bangalore, Nagarbhavi, and Sunrisers. Thank you one and all for being here and spending your time and gaining the knowledge regarding the topics, sir.
Thank you very much. Thank you so much, madam. Thank you. I
Thank you.
really thank and grateful for Dr. Amarnath Mishra and Dr. Kalpesh Kumar sir, and Dr. Padmakshi Lokesh, and all the supporting partners. As said, the Rotary Club Nagarbavi Bangalore and Sejal New Foundation, Dharani Pratisthana, and other partners, and all the audiences, lawyers, the medical fraternity, the law students who have taken an opportunity and taken a benefit of this program. I wish that this type of program will definitely enrich the legal knowledge in the population of the country. So, in this regard, I would like to thank everyone for joining this program. Thank you very much. Jai Hind.